Mediation. Is it a good thing in litigation? I'm going to take some time today and we're going to break down what exactly mediation is and whether it's a positive thing in litigation or whether it's a negative thing that we don't want. And in my opinion, which one ends up winning really depends on the facts and circumstances of the situation. I'm Shawn McBride. I'm a business lawyer. I work with business owners and business leaders to achieve their business goals and dreams. And part of that process is occasionally my clients get involved or embroiled in litigation. One of the things that happens during the litigation process sometimes is mediation. Mediation can also potentially be an alternative to litigation. So some folks will try to go down the avenue of mediation instead of litigation. Now, the one thing about mediation, at least in its purest form, is that it doesn't necessarily force a result. Mediation is about discussion, analysis, and about working through the process. So it doesn't guarantee an outcome. So at the end of the day, mediation may be a step to resolving a dispute that would otherwise be a lawsuit. But it may not necessarily be dispositive. It may not lead to a final answer. The parties may dig in and not work through the mediation process. So what is mediation? Let's take a step back and talk about what it is. In the basic version of mediation is you have the two parties on the two different sides, and they will come together through a mediator who will make the parties really discuss the relative value and merits of their side of the case and work back and forth about what the relative strength of each side is, what's likely to happen in litigation. And the goal is to move people to reaching a settlement. And so it's a lot less adversarial than litigation. It's more collaborative. It's a way for people to discuss and talk and get to an outcome. But again, mediation usually is not binding. There is no way to force an outcome. You can't force either side to settle during a mediation process. It often these days comes up as part of litigation. One thing that we'll see these days is parties may choose to go to mediation as part of litigation. They may talk and say, let's go sit down in front of a mediator and try to work it out before we prepare and spend tremendous time, money, and energy on a litigation or trial. Sometimes it will be court-ordered mediation. The judge that's in charge of routing the case will say, I want you guys to go, you guys, you girls, you team, you all, everybody involved in the litigation, I want you to go sit down in front of a mediator and try to work things out for you. Judges do this in an attempt to settle litigation, to clean up their docket, to have less to deal with. So it is a very real possibility that mediation may not just be voluntary, where the parties elect to do it as a way to streamline litigation, as part of a contract or agreement, or somehow otherwise voluntarily going into mediation. Sometimes mediation will be somewhat involuntary. Right? Again, the mediator can't force an outcome, but a judge may use their power in overseeing the trial, in being able to set the conditions for getting to trial, by being able to direct the lawyers to force the parties essentially to do a mediation. So one way or another, you may end up in mediation without your choice. Maybe an old contract was already signed, it had a mediation clause, maybe a judge is forcing you there. But in many, many cases, mediation is actually voluntary. The parties have said, let's try to work things out. Let's do that. And this may be as an alternative to litigation. It may be pre-litigation, in that nobody has filed a lawsuit yet, but they've said, I think I might file a lawsuit, let's go to mediation. Or another way you can end up in mediation is the litigation has commenced and the lawyers have gotten together and said, should we do a mediation? And both parties have agreed to doing a mediation. Or you might have a contract there, right? There's a couple different ways we can end up in involuntary mediation, and there's a couple ways we can end up in a voluntary mediation. In this show, I want to focus on those voluntary mediations and whether they're a good thing in litigation. And a big part of this is going to depend on the parties, right? Who is a party to this lawsuit and what is likely to happen at this mediation? So, are the parties far apart? Are they being reasonable? Can they work with each other? Right? To the extent that you can get a good discussion going and get some openness and honesty going, mediation can be a very powerful tool. Good mediators are known to help the parties expose their relative strength and weaknesses of their litigation positions. So if you're working through a mediation with a good mediator, odds are they're helping you to see what's good about your case, what's bad about your case, what should be changed in your case, and how to develop your case further should the mediation fail. So it can be a very, very powerful tool. And it might lead to avoiding a trial preparation. It may streamline things. And another benefit of mediation, depending on which side you're on with the litigation, is that you may be able to use mediation to have a more structured outcome, meaning that any settlement or agreement that you reach during the mediation to not go to litigation may have structures around when the payments are made, how the payments are made, may be paid in non-cash ways, such as through stock or assets. Right? There could be a lot of options for settlement in mediation that are just not possible or popular in litigation. In litigation, you're generally going to get put in front of a judge and or jury. That judge or jury is going to make a decision, and usually it's going to come down to money damages, i.e. dollars and cents. A dollar amount is going to be awarded from one side to the other, and that dollar amount is going to be ordered to be paid, usually at the time of the judgment. Right? Mediation could have a whole range of outcomes. It could be a combination of assets and money paid. It could be a transfer of assets. It could be a time payment, pay that this much there, this much next year, this much the year after. Many, many options in mediation. So a lot of this depends on where your perspective is. Now, of course, one of the real downsides of mediation that people that push mediation don't talk about is the time and expense. This is yet another thing for the lawyers to work on. And as many of you know, lawyers tend not to be inexpensive, right? They tend to cost money. They generally have high billable rates. And if you're in corporate litigation, you're probably paying hourly. So this is a cost. Both parties are going to end up generally paying their attorney's fees. And in some cases, depending on contract, depending on statute, other reasons, one party may end up paying the other party's attorney's fees. So if you're the loser and you go through a mediation before you end up in litigation, there's a chance that not only are you paying for your mediation expenses for your lawyer to prepare and participate in the mediation, but you end up paying the other side's cost to participate. So it can be very expensive from that perspective. And of course, the mediator is going to generally charge a professional fee to mediate. Right? They're going to say, hey, I'm going to come hear both sides. I'm going to listen to what's going on. But they want to get paid for that, and rightfully so. They're potentially adding a very valuable service, which has an expense to it. And so that adds to the cost. So mediation can be expensive, and it can be time-consuming from the perspective that your lawyer needs to prepare for it. You as the client may need to spend time for it. You may have to attend it. You may have to travel to attend it, depending on the nature of your trial and whether we move to a world where there's more in-person hearings and mediations. So there can be costs and expenses around mediations, and there's no guaranteed outcome. So I don't want to say that mediation is all roses, right? It's not necessarily the perfect solution to every litigation, but it does bring myriad benefits, right? You get to prepare like you're preparing for trial without going to trial. You get to have that frank discussion with the other side. You get to have an independent party involved in facilitating the discussion, and that can help a lot. It kind of gives you a preview of what a judge or jury might do. Whichever take that the mediator has on the different parties and their relative strengths and weaknesses and what they're saying and how it's weighing in the mediator's ears and eyes may give you a preview of what a judge and jury might do. And a really good mediator will generally understand the law, will understand the case, and they may apply pressure one way or another in a settlement. They may make a party realistic about their relative strengths to go to trial and to actually win. So I say there's a lot of benefits to it, to be weighed with the cost. So if you're a business owner that's thinking about potentially doing a mediation with a piece of litigation, I recommend you sit down and talk to your attorney and have a discussion about whether mediation is the best option. Your good attorney should be explaining to you the pluses and minuses of it. And hopefully you have that relationship. I do these videos to help business owners and business leaders understand what's going on in the business world. And so a good attorney should be leading you through a similar discussion. But you can watch these types of videos here on my channel, and you can be more knowledgeable so you can have a better discussion with your attorney when the time comes. You can say, I've already learned about mediation. I understand what the benefits are. Let's talk about the cost. Let's see if it's the right fit for my situation. And so hopefully today's video has brought that to light to you. If you have general questions and comments about business law topics you'd like covered, I'd welcome you to drop them below. Go ahead and comment them. But remember, comments on a channel like this are not confidential. Other people can see them. So don't put anything specific about you, your business, and certainly not anything that you want other people seeing, because they may be able to read them in the comments and you may lose confidentiality. If you want a confidential communication about this, reach out to an attorney of your choosing and have a discussion in that context with them. Welcome you to check out our library of past videos. There's a lot of stuff there. Give me suggestions for future videos in the comments, and consider subscribing to our channel for more tips. Thanks for tuning in today, folks. I'll see you for another video soon.